minutes time,
Yes, yes.
so that you can, at home, you can learn it by yourself.
Yes, yes. Sir, with your permission and with the permission of Hiranshi ma'am, can we proceed for the today's session?
Yes, sure.
Yes, yes. Thank you.
So, with the permission of your lordship, we will like to start this event.
Yes.
Yes. Good morning to one and all present here. I am Jitayu Yagnik, a coordinator of this event. I welcome you all on behalf of Sambhav Initiative in the two-day online workshop on civil laws. Today, we are privileged and honored to have with us Honorable Justice K.T. Sankaran sir, a former judge of Kerala High Court and the member of Law Commission of India. Before starting this session, we request you to follow some basic webinar etiquettes. I request all the attendees to keep their microphones on mute during the session. If you have any question, then please feel free to write the same in chat box. Kindly fill out the feedback form for the certificate purpose. Now, I would like to invite Sanvi, a volunteer of Sambhav Initiative, to take a moment to introduce the founder of Sambhav Initiative, Ms. Hiranshi Shah, before her welcoming speech. Over to you, Sanvi.
Ms. Hiranshi Shah is a remarkable individual with a distinguished career in alternative dispute resolution. She is a member of prestigious organizations like a Chartered Institute of Arbitrator in UK and the World Mediation Organization in Germany. She holds the title of being the youngest certified mediator in Gujarat, certified by the Ministry of Corporate Affairs, Government of India. Ms. Shah is also a member of esteemed institutions like Singapore International Arbitration Center, the London Court of International Arbitration, and the International Council for Commercial Arbitration. In her addition to professional achievements, Ms. Shah is also for expertise as a judge in various international and national ADR competitions. She has even been honored as a chief guest for Asia's Top 100 Influential Women Award, recognizing her outstanding contribution. Furthermore, Ms. Shah was also appointed as a conciliator of National Lok Adalat for pre-litigation and pending cases. Now, I would like to invite Ms. Hiranshi Shah for her welcome speech.
Thank you so much, Sani, for kind introduction. Good morning, everyone. Good morning to you, sir. On behalf of the Sambhav Initiative, I'm honored to welcome Honorable Justice K.T. Sankaran, sir, member of Law Commission of India and the former judge of Kerala High Court. First of all, thank you so much, sir, for accepting our kind invitation. It's honor and privilege to have you with us on for this online workshop on the civil law. Which is aimed to be shedding the light on the practical and theoretical aspect of the civil law. And we are organizing this workshop under the vision and the direction of our Honorable Patron-in-Chief and Patron, Justice C.K. Thakkar, sir, and Justice M.R. Shah, sir, former judges of Supreme Court of India. Thank you so much, sir. And also it's our great honor to have you with us. Thank you, sir, and welcome to on this workshop.
Thank you very much, ma'am, for the welcome speech. Now I would like to invite Mehak Soni, the Research Department member of Sambhav Initiative, to introduce Honorable Justice K.T. Sankaran sir, member of Law Commission of India and former judge of Kerala High Court.
Thank you, Jitayu. Hello, sir. Ladies and gentlemen, I'm honored and privileged to introduce the esteemed chief guest and keynote speaker of today's workshop, the Honorable Justice K.T. Sankaran, sir, a former judge of Kerala High Court who is currently a member of Law Commission of India. The Honorable Sir was born on December 25, 1954 at Thalakesari near Patambi, Palakkad, Kerala. Eventually, he pursued his legal studies at Saraswati Law College in Merkera, Kurg, Karnataka. He was enrolled as an advocate in 1979. He started practicing in Munsif Magistrates Court, Patambi, in 1979 and transitioned his practice to Kerala High Court in 1982. where the Honorable Sir continued to serve the cause of justice with dedication and diligence. On February 2, 2005, he was appointed as a judge of High Court of Kerala. He retired from service on December 25th, 2016. After that, he was appointed chairperson of Kerala Judicial Academy on January 5, 2017 for 3 years, and then appointed as a full-time member of Law Commission of India on November 7, 2022. Honorable Sir took various lectures on different topics from 1992 to 2022 for judicial officers of Kerala at Kerala Judicial Academy, the National Judicial Academy, Bhopal, the Jharkhand Judicial Academy, the Karnataka and the Odisha Judicial Academy, and many more. So let's welcome the Honorable and respected K.T. Shankaran sir.
Thank you. Shall we proceed with the subject? I believe
Yes,
that
sir.
it is audible to all. If it is somebody feels that it is not audible, please tell me. Okay. Now, the subject assigned to me, or rather preferred by me, is res judicata. Res judicata you will find in section 11 CPC, Code of Civil Procedure 1908. On a reading of it, it may appear to be easy. And to understand it, it is easy. To comprehend it is easy. To apply it on practical problems, it is very difficult. I have categorized it in 27 topics. And I will give the headings to you and also give the citation so that after fully reading all those decisions, you will clearly understand what the position is. Two things are there. One is lecturing and going back. I believe that when I go back and when you go back, there must be something take home for both sides. And that take home is, I will give you in the form of tips, which are for practical application. So apart from the theory, you must have a practical knowledge of the subject. Now, before coming to section 11, I think many of them are young lawyers. Is it not? Young lawyers. First of all, young lawyers always tell me that CPC is the most difficult subject and it is very difficult to understand. My answer is, if you wholeheartedly study CPC for 3 months, you will ultimately say that CPC is your friend and it is not a foe, your foe. And it is very easy to understand it, but there is a method of study. First of all, whenever any act is taken, you must understand the scheme of the act, the purpose for which the act is made, the object sought to be achieved, and how it is implemented, sought to be implemented. And then some special statutes will have special authorities. The procedure, therefore, the limitation aspect, so many other aspects. And also, the scheme will make you aware as to how the law is to be approached. Here, so far as CPC is concerned, it is mainly a procedure. And how to know it is a question. There are several sections and several orders and rules. Why it is so is the first question. Second question is how to approach it and what is the difference between sections and orders and rules. First is that many will answer that it is for convenience. It is true that it is for the purpose of convenience and for proper application of it in a country like India, vast country like India, where circumstances differ from state to state, and even in different states, vast states, there may be from place to place. Therefore, to have flexibility in application, there is a procedure set up. That procedure you will get in part 10 of the CPC from sections 121 to 131. Please note, section 121 to 131, part 10. There it speaks of constitution of a rule committee for every high court. What is rule committee? Rule committee consists of three senior judges, plus local judicial officer and a secretary. What is the duty of the rule committee? The rule committee has power to submit a report, either altering, amending, or incorporating or introducing any part in the orders and rules. So one order which is prevalent in UP may not be available in Tamil Nadu, or it may be different. So different procedure can be provided in orders and rules to different states. And the rule committee will submit a report to the High Court. The High Court, full court means the meeting of all the judges in that High Court. The full court of the High Court will consider it, and if it is acceptable, it will accept it. Then after accepting, it will be sent to the government. Government's approval is required. And then notification will be issued. Then it becomes the rule of that particular state. So that when you see the orders and rules, you will get state amendments as footnote in many of the barracks and many of the commentaries. These are all the amendments made by the state concerned, so that it is very flexible in those states, flexible in its application, and practical in its application. Now, whether the question arises whether the sections can be amended by the states, can be, but presidential assent is required. For example, if you see section 54, Karnataka has made an amendment, state amendment, but president's assent is required. So that it is very easy for the states to amend the orders and rules in that orders. Every order contains rules. Orders and rules, the state can amend, and that will be applicable in that state. This is why it is made in such a way. Therefore, complete flexibility is ensured, and it can be properly applied. That is why even after 1908, all these years, it stood the test of time. Even before 1908, CPC was there, but the whole of CPC contained sections. And now it is orders and rules, sections, orders and rules. So we have to approach the law in this fashion. Now we have understood the scheme of the CPC in various orders and rules. You can see there are some orders where only few rules are there. There are orders like Order 21, which contains 106 rules. So big as a statute itself. So that it is very complicated. Order 21 relates to execution of decrees and orders. So it is very exhaustive, long, lengthy, and it is difficult also. Now we come back to our subject. I am requested to take not only res judicata, but after time, if time permits, I will also give you tips to how to work on appeals, revisions, review, reference, etc. I will not take any class as such. I will not give it in detail because time will not permit. But I will give you how to study it. I will give you an idea as to how to study it so that it is very easy. Now we come to section 11. How many of you know by heart the ingredients of section 11? You have to make it by heart. Why? Because whenever a problem arises, to comprehend it, to apply it, and to understand it, it is necessary to have in mind the ingredients. Let us see what are all the ingredients. It is a bar. Bar for what? No court shall try, which this definition I have studied during my LLB days. I have not forgotten. I remember even now. So this is the right time for you, for young members, young lawyers and law students, to learn it. If something is required to be learned by heart, you do it. There is nothing wrong, so that all the ingredients will come to you abruptly. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. It is a very long definition. Now we will dissect it. What is it? It is a bar of jurisdiction to try a suit or issue. Issue you will get in order 14 of the CPC when issues of facts, issues of law, and issues of law and fact together. You will get in order 14 CPC. No court shall try any suit or issue. It is a bar. It is a complete bar. Which suit or issue in which the matter directly and substantially in issue. So in that suit, there is a matter which is directly and substantially in issue. We have to find out what is in a suit, what is directly and substantially in issue. And then what is directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties, litigating under the same title in a court which is competent to try the subsequent suit. So we have got two courts, two decisions, one decision rendered already. That decision will bar the trial of the second suit. So the principle is that there should be an end to litigation. Interest republicae ad sit finis litium. It is to the interest of the state that there should be end to litigation. And no man shall be vexed twice for the same cause. These are the two principles on which res judicata is based. Now, again coming to the definition. No court shall try any suit or issue in which the matter directly and substantially in issue. So that matter, what is the matter directly and substantially in issue, has been directly and substantially in issue in a former suit. So there is a former suit in which the matter which was directly and substantially in issue is the same thing as the matter directly and substantially in issue in the second suit. So let us say first suit and second suit. First suit is already decided between the same parties. So what was directly and substantially in issue in that suit, first suit, is directly and substantially in issue in the second suit. And then what happened to the first suit? Between the same parties, in respect to the same title, and it was in a court which is competent to try the subsequent suit. These conditions must be satisfied. And it was heard and finally decided by such court. Such court means court in which the first suit was pending. So there was a first suit between the parties in respect to the same title, and it was decided fully, finally by such court as between the same parties in respect to the same title. Any doubt on it? So there is a first suit. The question of considering the bar is of the second suit. So for which, what are the conditions? Conditions are yes, audible now? Hello?
Yes, sir, you are audible.
Audible. Something happened in the meantime. Now, there was a first suit. It was pending in a court which is competent to try the subsequent suit. It was between the same parties. It was in respect to the same title. And the first suit was decided by the court finally. And that finality is attached to that decision. So when the same question is agitated in the second suit, that second suit cannot be tried. It is a bar. That is res judicata. Now, this is not all. There are 8 explanations to it. 8 explanations. Let us see what are the explanations. Now, so far, is there any doubt with respect to the definition? Anybody can ask the question. So far, the first part of section 11 is concerned, which we have dealt with now. Is there any doubt? Is there any doubt? I presume that there is no doubt.
Sir, we have kept a question hour round after the after
Okay.
your lecture
Okay.
is delivered.
Okay. Now, 8 explanations I said. Explanation 1. The expression former suit shall denote a suit in which has been decided prior to the suit in question, whether or not it was instituted prior thereto. What does it mean? There is a litigation between A and B. A instituted a suit against B in 2022. B instituted a suit against A in 2023. So 2022 suit was filed by A and 2023 suit was filed by B. Same party, same question, same property. But 23 suit was decided first. So which will operate as res judicata for the second suit? Which is the first suit? First, which is decided first in point of time. It is not the date of filing that matters. It is the date of decision that matters. What operates as res judicata is the former decision. So irrespective of the question whether it was instituted prior thereto, the question is which was the first case decided, first decision. That decision will operate as res judicata for the purpose of the other suit, no matter whether it is instituted prior in point of time. This is explanation 1. 2. For the purpose of this section, the competence of the court shall be determined irrespective of any provision as to right of appeal from the decision of such court. That is self-explanatory. No explanation is required. 3. The matter above referred to. We have seen matter directly and substantially in issue. That is a matter. You cannot include everything in the definition. That is why all these explanations became necessary. The matter above referred to must in the former suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. It is not everything that will operate as res judicata. It is alleged by one party and denied by the other. And an issue arises when a material fact or law is alleged by one party and denied by the other, then it will constitute an issue under Order 14. Rule 1. Matter above referred to must in the former suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. This is one of the conditions. That is a matter. The matter is explained. Explanation 4. This is very important. Explanation 4 is very important, and there are thousands and thousands of decisions on this point. This is otherwise called constructive res judicata, and somebody call it matter heard as might and dot theory. Might and dot theory. Let us read explanation 4. Any matter, here also see the word matter. Any matter which it is not in the common parlance. The matter is defined, explained in explanation 3. So the matter which is found in section 11 is not a matter which you call in common parlance or ordinary parlance. It is a matter which is defined here. Explanation 4. Any matter which might and ought to have been made a ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. We will explain with the help of decisions. This is what is called might and ought. See, for example, A filed a suit against B for return of money. A alleged that B borrowed the money on the basis of some document, promissory note, check, or any other negotiable instrument, or any other agreement, or any other thing. B said, the suit is barred by limitation. B did not raise the contention that the document is forged or it is manipulated. The court decided the question of limitation and held that the suit is within time, it is not barred by limitation, and accordingly the suit was decreed in favor of A. Later, B files a suit against A, saying that the document which was relied on in the earlier round of litigation is a fabricated one. Can he raise it in the second suit? No. Why? Because this is a matter which might and ought to have been raised in the first suit. A matter which is ought to have been raised in the first suit, but having not raised, then there can be no decision. One of the ingredients of Section 11 is heard and finally decided. So a matter which is not raised at all, how can the court hear it and decide it? It is not there. Then there is a deeming fiction. Shall be deemed to have been a matter directly and substantially in issue. If it is a matter directly and substantially in issue, it must have been decided. So there is a decision rendered. So a matter, by saying that a matter which you should have made a ground of defense or attack, which not so made, shall be deemed to have been a matter in issue. Matter directly and substantially in issue means a matter which you should have raised, but not raised and therefore not decided, but it shall be deemed to have been raised and decided against you. I think it is clear. You will go to the decisions, it will be very clear. So a matter here is not decided. One of the ingredients of Section 11 is that a matter which was already decided between the parties cannot be agitated again. Here, a contention which was available to a party, but he did not raise it, and therefore the court had no occasion to decide it. Still, if it is a matter which ought to have been raised by way of explanation 4, then it shall be deemed to have been heard and finally decided, in which case it will operate as res judicata even though it was not decided. So by a fiction, something is created. A theory is developed that a matter which you should have raised has been decided, and therefore it attained finality, and therefore second suit is not made. Explanation 5. Any relief claimed in the plaint, which is not expressly granted by the decree, shall for the purpose of this section be deemed to have been refused. I filed a suit against you, claiming certain money, say 10 lakhs. I claimed interest on the principal amount. The court granted a decree in my favor for 10 lakhs, but it did not decide the question of interest. I did not file an appeal. My right was to file an appeal or a review. Review means half the court fee you have to pay. But I could have filed an appeal paying the same court fee. Court fee would have been refunded. But I did not file an appeal. It became final. So a matter which was not decided by the court, interest was raised, the question of interest was raised, but it was not considered. It shall be deemed to have been considered. When you raised it, but the court did not decide it, you have to challenge at the appropriate time by either appeal or review. Explanation 5, that is 5. 6. Where persons litigate bona fide in respect of a public right or of a private right, claimed in common for themselves and others, all persons interested in such right shall, for the purpose of this section, be deemed to claim under the persons who litigate. What is the meaning of it? 2 persons or 3 persons or 1 person file a suit against several persons, and the plaintiffs agitated a thing which is available to the whole villagers in the area, hundreds of persons. They ventilated the grievance of hundreds of persons. They represented. There was no vitiating circumstance like collusion or fraud, and it was decided. Then it is binding on all the 100 persons. Even though they are not eo nomine on record, they are not parties to the suit. This is the principle. I will give with a reference to an example of the Supreme Court decision. There was a case against RSS for eviction. RSS was represented by the president, secretary, and an office bearer. It was contested all throughout, and RSS failed. When it was put in execution, RSS raised a contention that RSS is not a registered body, it is a loose association. Therefore, the suit against an office bearers is not maintainable, or it does not bind all the members. But this contention again in execution went up to Supreme Court, and the Supreme Court said explanation 6 of CPC will apply, and therefore it is binding on all the members of RSS. I'll give the citation in the course of time. Now, along with explanation 6, you have to see another provision in the CPC. That is Order 1, Rule 8, representative suits. That is, if there are 100 persons in a village or 1,000 persons in a village, thousands of persons in a village, who use a right of way or road and somebody infringes it, any one or more of such persons can file a suit on behalf of all or against all. Many of them are unknown. Such persons can be represented. So a representative suit can be filed by the plaintiff representing other interested parties and against a defendant representing all other similarly situated persons. And it will be binding on all. That is representative suit. There are built-in safeguards as to how the representative notice should be served, whether it can be withdrawn, whether it can be compromised, and all those things. You read Order 1, Rule 8 and the commentaries thereof. Explanation 7. The provisions of this section shall apply to proceedings for execution of a decree, and references in this section to any suit issue or former suit shall be construed as references respectively to a proceeding for the execution of the decree, questions arising in such proceeding, and a formal proceeding for the execution of that decree. Nothing new. That is reference to a suit that applies to execution proceedings also. So in the course of execution proceedings, something is decided finally between the parties. It cannot be raked up again. The principle of res judicata will apply. Res judicata as such will apply. That is the explanation 7. Nothing else. That just like suits, it will apply to execution also. Explanation 8. An issue, this carefully read. An issue heard and finally decided by a court of limited jurisdiction, competent to decide such issue, shall operate as res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit or the suit in which such issue has been subsequently raised. What is the meaning? One of the main ingredients of applying section 11 is that the second suit, the first suit must be in a court which is competent to try the subsequent suit. And the first court decided the question. It is binding on the second court between the parties, binding on the parties in respect of the second suit pending in the court. So the competence of the court was the question. What competence, whether it is pecuniary jurisdiction, territorial jurisdiction, and all those things, these are all again complicated questions I will answer with reference to decisions. So Supreme Court. Now, what does this explanation 8 mean? There is a court of limited jurisdiction. It has got to decide only certain issues, not the whole suit. Such court decided that issue. Whether it is binding on the parties in a subsequent regular suit is the question. It is, notwithstanding that the court which decided the first suit was not competent to try the subsequent suit. One of the ingredients of section 11 is that it was pending in a court which is competent to try the subsequent suit. So the court of limited jurisdiction is not competent to try the subsequent suit. Still, by this fiction, it is made final. If the court which tries the first suit is a court of limited jurisdiction. I will give an example. That is, there are land reforms legislations all throughout India. It is not in court. Most probably in some land tribunals or some other tribunals, whatever name you may call. there is an exclusive jurisdiction vested in such tribunals. And even in respect of a suit in which such question arises, it has to be referred to there. Depends on state to state. That court of limited jurisdiction, tribunal, decides it. That is final between the parties. Not only in that proceeding. Same question arises in a subsequent suit. It is binding on the parties and it will operate as res judicata. The first decision by the tribunal will operate as res judicata in the second suit. But you have to note a condition which is available, which must be satisfied in section 11 is that the former suit must be pending in a court which is competent to try the subsequent suit. Here, the first court tribunal which decided the issue was not competent to try the subsequent suit. Still, by a fiction, that is explanation 8, it has been made so. So, even if a court of limited jurisdiction having only certain rights to decide, that will operate as res judicata in a regular suit filed subsequently between the parties. I think the position is to some extent clear. Now, this is a subject which in our Judicial Academy, it takes minimum 10 days of 3 hours each, 30 hours, 25 to 30 hours subject matter for study. But we are finishing it in hardly 2 hours. We have to do it. Now I will straight away go to the decisions of Supreme Court. Excuse me for taking an Ayurvedic medicine for cough.
Search Department.
Hello.
Honorable Justice K.T. Sankaran, sir, Member of Law Commission of India.
Can I resume?
Hello. Yes, sir. You are audible.
Now, I said that I have divided into 27 subheadings. We will take one by one. Question is whether section 11 is exhaustive. Please note whether section 11 is exhaustive. It is not. The principles of res judicata will apply. Even though res judicata as such may not apply, the principles will apply. For example, writ proceedings. Article 226. Take section 141 of the CPC. 141 of the CPC, which says, 141 says, the procedure provided in this code in regard to suit shall be followed as far as can be made applicable in all proceedings in any court of civil jurisdiction. But an explanation is there. In this section, the expression proceeding includes proceeding under Order 9, but does not include any proceeding under Article 226 of the Constitution. So, in respect of Article 226 or Article 32, res judicata in section 11 as such may not apply, but the principles will apply. And therefore, in a writ petition before the High Court, some points are decided between the parties finally. It cannot be again decided. It cannot be again put up for decision. The principles of res judicata. Therefore, section 11 is not exhaustive and the principles will apply. Please note, AIR 1953 Supreme Court 33. 53 Supreme Court 33. And AIR 1931 Privy Council 114. 31 Privy Council 114. And AIR 1981 Supreme Court 2198. And if the organizers so want, I can send the full notes running to more than 150 or 200 pages to you by email, so that it can be made available to all the participants. I do not claim any copyright. Anybody can use it.
Sure. Thank you so much, sir. We will share with the participants.
Okay. So that I will send the notes to you by email. You need not take down, but anyhow, you take down the decisions. I am not saying the name of the case, it will take time. Now, second heading is, no, first heading is not exhaustive, doctrine. What is the doctrine of res judicata? Meaning is, I am not reading the Latin maxim, a man shall not be vexed twice for the same cause. And it is to the state interest of the state that there should be an end to litigation. These are the two Latin maxims. It is there, it is in the notes. That is point number 1. Point number 2, section 11 is not exhaustive. Third point is heard and finally decided. Matter, if a suit is decided on a technical ground, like limitation or something, or it is not properly framed, or there is multifariousness, or non-implementment of necessary parties, and all those things, technical things. And if a former suit is dismissed without any adjudication of the matter in issue, merely on technical ground of non-joinder, it cannot operate as res judicata. Please see AER 1996 Supreme Court 2367. 2367. 96 Supreme Court. Next heading, decision on merits and technical ground. Decision on merits and technical ground. Please note AER 1995 Supreme Court 2001, same as 1995 Supplemental 4 SCC 286. 1995 Supplemental 4 SCC 286. That is Most Reverend PMA Metropolitan, the church case of Kerala. Several rounds of litigation were there. For a century, the litigation, see, even after the decision of the Supreme Court, it has not ended. The fight goes on. In this case, paragraph 57. Consequently, where a suit is decided both on merits on technical ground by the trial court, and the appellate court maintains it on technical ground of limitation or suit being not properly constituted, then the decision rendered on merits by the trial court ceases to have finality. What does it mean? See, a suit is there. 2 points were considered. One is limitation. The other is on the merits. The trial court decided both the questions. But the aggrieved party filed an appeal. The appellate court confined its decision to the question of limitation, and the suit was disposed of as barred by limitation. What will happen to the decision on the merits? Whether that will operate as res judicata? No. Why? Because the suit is dismissed. If that decision goes against the defendant, defendant need not worry. In the first suit, it was decided against the defendant. And the limitation question also was decided against the defendant. Defendant filed an appeal. The appellate court accepted the defendant's contention and said that the suit is barred by limitation. And on that ground, the suit is dismissed. The defendant need not worry about the decision rendered on the merits because the finality will vanish. There are two other very old decisions of Supreme Court, AER 1917, 17, Privy Council 201, and a Calcutta decision of 1897, I have noted in the notes. Next subheading, matter directly and substantially in issue. Matter directly and substantially in issue. Please note AER 1996 Supreme Court 2911. 96 Supreme Court 2911. That was a case filed by an employee for an injunction to restrain the opposite party from removing or terminating his service. Interim injunction application was dismissed. He filed an appeal. Appeal was also dismissed. And thereafter, the employee approached the Rajasthan Shops and Commercial Establishment Act, challenging the dismissal. Because in the meantime, when the interim injunction application was dismissed by the civil court, he was removed from service. Removal from service was challenged before the Shops and Commercial Establishment Authority. and the employee succeeded, he was ordered to be reinstated. The matter went up to Supreme Court, and it was contended that the interim injunction application was dismissed by the civil court, and that will operate as res judicata. The Supreme Court did not accept that contention. It has not attained finality. Suit is still pending. Suit was subsequently dismissed for default, and therefore it is not a decree. Likewise, there are other decisions also. I am not saying it. You may go through it. Next heading is constructive res judicata. AIR 1997 Supreme Court 809. 1997 9 SCC 66. Next is 1996 3 SCC 54. 96 3 SCC 54. Then 1995 6 SCC 614. There it was said by the Supreme Court that it is ordinary questions of law or fact and question regarding the constitutionality or otherwise of a statute are different concepts. Somebody questioned the constitutionality of a decision, of a statute, and it was decided one way or other. I will read para 19. It would then have to be seen the twin play of the notion of deemed constitutionality and the bar of constructive res judicata. Raising the constitutionality of a provision of law, as it appears to us, stands on a different footing than raising a matter of a bare question of law or mixed question of law and fact. So a statute is there. In respect of the rights or liabilities under the statute, a case arose. The parties did not challenge the constitutionality of that statute. The court decided the case. Subsequently, the constitutionality of the statute was challenged. Then the other party said, this is barred by constructive res judicata. You should have, ought to have, might have raised this question in the earlier suit. There the Supreme Court said, parties can presume very well of the constitutionality of any statute, and that they did not challenge it in the first round of litigation will not operate as constructive res judicata. Please read it. Next is 1994 4 SCC 94 4 SCC 53. Since I am sharing the notes, need not say anything. Here also there are several things to be said. Please see the notes and footnote there. Next is 9610 SCC 561. Commissioner of Income Tax versus P.P. Kumar in a case from our state. Very interesting case. A person was working as income tax officer. He was dismissed from service. He challenged the order of dismissal in a suit. The suit was decreed in his favor. He was reinstated. Thereafter, he approached the High Court in a writ petition saying that arrears of wages, arrears of salary should be paid. High Court allowed that writ petition, and arrears of salary was also ordered. That interest on arrears should be paid. Then the question arose whether when he filed the writ petition in the High Court claiming arrears of salary, whether he should have claimed interest on arrears as well. And having not raised it, whether he is barred by constructive res judicata. Supreme Court said he is barred by constructive res judicata. Next is (1989) 3 SCC 151. 89 3 SCC 151. 2000 Volume 3 SCC 87. 2000 Volume 3 SCC 87. 2010 Volume 10 SEC 141. 2010, Volume 10 SEC 141. This is a very interesting decision which you have to read fully. Whenever you find the decision of Justice R.V. Ravindran of Supreme Court, you make it a point to read it. Why? Because that decision will deal with all ancillary aspects and the aspects which arise for consideration in great detail, in simple language, no difficult word, interesting reading, and you will understand the whole gamut of that subject. This is name of the case is Alka Gupta versus Narendra Kumar Gupta. Difference between Section 11 and Order 2 Rule 2. What is Order 2 Rule 2? You file a suit. You have got 2 remedies open. You claim only 1 remedy. You cannot reserve. You did not get permission of the court to reserving that remedy. You are precluded other remedy which was omitted to be sued. Whereas res judicata is a thing which was already there. The definition goes like this. Res judicata relates to the plaintiff's duty to put forth all grounds of attack in support of his claim. Whereas Order 2 Rule 2 of the Code requires the plaintiff to claim all the reliefs flowing from the same cause of action. That is a difference. And Order 2 Rule 2 and constructive res judicata. Constructive res judicata deals with the grounds of attack and cause of action. So there is a subtle difference between Order 2 Rule 2 and Section 11. That is very beautifully explained in Alka Gupta's case. With that heading is RSS case which I said. AER 1996 Supreme Court. 96 Supreme Court 1211. 1996 3 SEC 149. I said about the instance where or an Order 1 Rule 8 suit should have been filed as a representative suit. But that contention was negatived on the claim on the ground that explanation 6 of Section 11 applies and therefore it is binding on all. Then is 1991 3 SEC 114. Then 1986 1 SEC 100. 1986 1 SEC 100. Section 11 applies to public interest litigation as well. It must be proved that the previous litigation was a public interest litigation, not by way of private grievance. It has to be a bona fide litigation in respect of a right which is common to and agitated and common for others. If it is not really a public interest litigation, how can it affect the persons who are not parties to the suit or litigation? A writ petition is filed as a PIL, either before the Supreme Court or High Court. In fact, it was really no public interest was involved. It was instigated by some interested person. And he invited a decision against himself. Does it bind others? No. Then we have to prove that this is not really a public interest litigation. It was a collusive affair. Next is 1965 Supreme Court 1049. In this case, and the case next following, that is AER 2006 Kerala. In this case, AER 1965 Supreme Court. 1965 Supreme Court 1049. A theory of substantial representation is mentioned. What is that theory of substantial representation? I will explain. A filed a suit against B. B died. What is to be done by A? A has to file an application to implead the legal representatives of B and continue with the suit. Even if A gets a decree against a dead man, namely B, decree will be nullity. So it is necessary to implead the necessary parties, namely the legal representatives. They must be heard. That comes under Order 22 of the CPC. Now, B had 5 children and a wife, widow. All these 5 children are employed elsewhere. They are not available in the native place for several years. Therefore, their whereabouts are not known. That A does not even know that whether B had 5 children. It may so happen. He filed an application for impleading the widow and 4 children. One was left out. Without knowing, he made enquiries and found that this man B, defendant, had only 4 children and a widow. He filed an application to implead them. They were impleaded, and the suit was decreed in favor of A. When it was sought to be executed, the man which is omitted to be included filed an application saying that he is not bound by the decree. Decree is null and void so far as he is concerned. There, this theory of substantial representation applies. The persons already on record substantially represent the estate of the deceased, namely the defendant B. Though all are not impleaded, some are impleaded after making inquiry, and it is a bona fide litigation. Then it is binding not only on the persons who are made parties as legal representatives, but on the person who was omitted to be impleaded as well. This is called the theory of substantial representation. Next is 2021 SCC 1, Ayodhya case. (1977) to SCC. And in Ayodhya case it was said, provisions of Order 1, Rule 10, Rule 8 do not control the applicability of Explanation 6. This is what he said in RSS case. Order 1, Rule 8, representative suit is there. And Explanation 6 to Section 11 is also there. Question is whether Order 1, Rule 8 controls Explanation 6. And it was held in Ayodhya case by the Supreme Court. Sorry. That Order 1, Rule 8 does not control Explanation 6. Next is 1977 to SCC 181. 77 to SCC 181. Next is Explanation 8. Explanation 8. Court competent to try such subsequent suit. What does it mean? Court competent to try such subsequent suit. 96 to SCC 520. There a contention was raised. If the court does not have territory, in a court which is competent to try the subsequent suit, is the expression used in Section 11. What is competent to try the subsequent suit? First suit was between A and B. It was in court X. Second suit is in court Y between the same parties. So a contention was raised that the first decision between A and B in court X would operate as res judicata in respect of the litigation in court Y. Then the party in court Y says, no, it will not apply because Y court is not competent to try X suit. True. Why? Because territorial jurisdiction is not there. Whether that is sufficient or in the absence of territorial jurisdiction as well, the decision rendered by a court would bind the parties. This was the question which was decided. And it was held. The acceptance of the contention urged on behalf of the respondent is that for the purpose of section 11 of the present code, the competence of the court which has decided the earlier suit also postulates territorial jurisdiction. But it was rejected. Why? If it is held by a foreign court, first suit was decided by a foreign court, it will be binding on the court in India in view of section 13 of the CPC. But if it is in a court X decided, second suit is in court Y, saying that court Y, in court Y the suit is not barred because court Y was not competent to decide court X case because it had no territorial jurisdiction. That contention cannot be accepted. So territorial jurisdiction is not a question coming within the competence of the subsequent suit to decide the subsequent suit. Next is 1994 2 SCC 14. There are pecuniary jurisdiction. A suit was filed in one court, X court. It had a pecuniary jurisdiction. Second suit was filed in a court which is having a different pecuniary jurisdiction. That is larger court. And it was contended that the first court could not have decided the second case because it was beyond its pecuniary limits. Such an argument will not lie. So the pecuniary jurisdiction is out of question for the purpose of deciding the competence of the court which decided the first suit. And that is the reason why explanation 8 was introduced. In this case, it is also a case from Kerala which went up to Supreme Court 94 to SCC 14. Such type of argument led to introduction of explanation 8. Very detailed discussion is there. Then 19 AER 1989 Supreme Court 2240. Summary nature suit, no res judicata. 82 Supreme Court AER 82 Supreme Court 20. Small cause. AER 2000 Supreme Court. AER 2000 Supreme Court 3279. AER 2000 Supreme Court 2301. Under this heading, it is over. Decision on the question of jurisdiction. Now it is 12:05. Yes. Next heading, decision on the question of jurisdiction or pure question of law unrelated to the rights of parties. Decision on the question of jurisdiction or pure question of law unrelated to the rights of parties. Jurisdiction, one aspect. Pure question of law unrelated to the rights of parties. There is no res judicata. I will give an example. There is a rent control court in every state. In certain statutes, state statutes, there is a provision. A petition is filed before the rent control court for eviction on certain grounds. If the title of the landlord is denied, there is a provision there in some of the statutes that the parties will have to fight before the civil court. So in this particular case, what was done is that the defendant raised a contention that the plaintiff did not have title. And therefore, it has to go before the civil court. Accepting that contention, the rent control petition was dismissed. Naturally, the plaintiff, the petitioner, rent control petition, petitioner, the rent control petition, filed a suit against the defendant. And there, at that time, the defendant said, no, civil court has no jurisdiction. It is a rent control court which has jurisdiction. Court said, no, you cannot blow hot and cold at the same time. Therefore, you are raised the contention other way about in the earlier round of litigation. And therefore, you cannot raise it. The matter went up to Supreme Court. And the Supreme Court in Isabella Johnson versus Susai, that is 1991 1 SCC 494 held that if it is a pure question of law, in our opinion, the contention of the learned counsel for the appellant cannot be upheld. We find that where, however, the question is one of purely law and it relates to the jurisdiction of the court or a decision of the court sanctioning something which is illegal by resort to rule of res judicata, a party affected by the decision will not be precluded from challenging the validity of that order under the rule of res judicata. For a rule of procedure cannot supersede the law of the land. So if it is where the decision is on a question of law, unrelated to the rights of parties, it does not operate as res judicata. Then 1971 SCC 613, that is referred to in Isabella Johnson. Then AER 2011 Supreme Court 3001. 2011 Supreme Court 3001. AER Supreme Court, AER 1965 Supreme Court 1325. With that heading is over. Next heading, inter-party judgment. Inter-party judgment. There I will cite only one or two decisions. AER 1984 Supreme Court 589. See the facts of that case, then only you will understand. 1987 1 SCC 727. There also facts are to be read. And it was also held in that decision. It is settled law that the principle of res judicata applies to two stages of the same litigation. In one stage of the litigation, there is only one suit. In the initial stage, a question was raised in an interlocutory application. A receiver application was filed by the defendant. A receiver should be appointed. Or the plaintiff filed an application for appointing a receiver. Then that was contested by the defendant. The court dismissed the receiver application. Suit was for partition. And the plaintiff said that the defendants are mismanaging the property, wasting the property, and therefore a receiver should be appointed. The court considered all the aspects and dismissed the receiver application. After 1 year, in the same suit, another application is filed by the plaintiff. Whether it can be allowed? No. Why? Because res judicata applies to the two stages of the same proceeding as well. But where there is a change of circumstances warranting interference, res judicata will not apply in the same suit. Next heading, two or more suits tried together. Two or more suits tried together. Appeal against one decree only. Appeal against one decree only. Scope of res judicata. I will give an example. This is what is meant. A filed a suit against B. During the same time, B filed a suit against A also. Same question, same property. Both these suits were jointly tried. What is the provision in the CPC for joint trial? No provision. Section 151 is only provision. Inherent power. Suits were jointly tried. And a common judgment was passed. That is, A filed a suit against B on the same question, same property, same set of facts. B filed a suit against A. Both the suits were tried together and it was decided in a particular manner. A files an appeal against one judgment and decree only. He does not file the appeal against the other. His suit was dismissed. He filed an appeal against that. The other suit was decreed. He did not file an appeal. A filed a suit against B. It was dismissed. Same court tried another suit filed by B against A that was decreed against A. A filed an appeal before the appellate court challenging his dismissal of his suit, but he did not file an appeal against the decree of his against him. What will happen with respect to the other decree, which is not appealed against? That decree which is not appealed against has become final, and that will operate as res judicata in respect of the appeal which is filed. I think I am making myself clear. A files a suit against B, B files a suit against A. The same court. Both these suits were tried together. A suit was decreed, A suit was dismissed, and B suit was decreed. A filed an appeal against his dismissal of his suit, but A did not file an appeal against decreeing the suit filed by B. So one decree in a suit filed by B is not appealed against. What will happen to the appeal filed by A? The appeal filed by A will not be maintainable. It will be hit by res judicata because of the earlier decision which is not appealed against. That is the principle. So whenever there are two cases, you advise the parties correctly and file two appeals. When common questions are decided by the court in two suits, you should not avoid anything. You should file two appeals. Or in another case, there is only one suit. A suit for partition or something where several parties are there. Suppose there are 10 defendants. Defendant number 1 files an appeal against that decision. Defendant number 5 also files an appeal. Both these appeals were decided together and two decrees were passed. The plaintiff lost. Plaintiff files an appeal against only one decree of the appellate court. There, this principle will not apply because it was necessary to file only one second appeal. Because the suit was only one. Where two suits are there, two appeals must be there. When one suit is filed and there are several appeals against it, second appeal need be only one. That is also decided in these cases. Please note the decisions AIR 1993 Supreme Court 1202. AIR 1953 Supreme Court 419. This question was considered. It was not necessary to file two separate appeals in this case. That is 1966 AIR 1966 Supreme Court 1332. AIR 1974 Supreme Court 1320. 76.3 SCC 528. 1995 Supplemental 1 SCC 405. AIR 1996 Supreme Court 1332. Very detailed facts are there. Next heading, res judicata, general principles. Res judicata, general principles. Income tax proceeding. AIR 1992 Supreme Court 377. Generally speaking, income tax proceedings, 1 year's financial year's income tax, a decision was rendered by the authority. Naturally, that will not operate as res judicata in the subsequent financial year unless the fundamental aspect permeating through the different assessment years has been found as a fact, one way or other. If the same question, same set of circumstances happens in the next financial year also, the first financial year, the earlier financial year, the decision will bind in the second one also. Otherwise, it may be quite different sometimes. Next is a 1987 2 SCC 591. Same point. AER 1981 Supreme Court 2198. AER 1965 Supreme Court 1153. Constitution bench decision. Article 32, 226, all decided. Decision in earlier petition on the merits. Principles of section 11. Section 11 is not exhaustive and therefore the principles will apply. Constitution bench decision. Gulab Chand Chotala. We therefore hold that on general principles of res judicata, the decision of the High Court in a writ petition under Article 226 on the merits on a matter after contest will operate as res judicata in a subsequent regular suit between the same parties with respect to the same matter. So a writ petition, the decision will operate as res judicata, principles of res judicata will apply in a regular suit. Constitution bench says, and it is followed in all the subsequent decisions. Next is identity of title, not identity of property. What does it mean? I will give the citation, but I will explain what it is. A person acquired title in respect of two items as per a single document. Same set of circumstances, same derivation of title in respect of both the items. One item, if a person does not have title, the second item also he does not have title because the same derivation of title. In respect of item 1, there was a litigation. And it was found that the plaintiff's claim is not acceptable. He has no title. In respect to the second item, another litigation. Then the first litigation was said to be res judicata in respect of the other. Then the plaintiff said, no, this is in respect of another item of property. But it was answered saying that it in respect of the same title. It is not the identity of the property that matters. It is in respect of the same title. The title which was agitated in the former suit and subsequent suit was the same. Irrespective of the question whether the property is same or the identity of the property is the same, that has to be finally decided. It will operate as res judicata. You see the following decisions. AER 1986 Kerala 251, a full bench decision. Then AER 1953 Supreme Court 53, 53 Supreme Court 33. Next heading, decision on more than one point. Decision on more than one point, each of which by itself sufficient for the ultimate decision whether res judicata applies. 2 points decided. The decision on each point will result in a final decision which will operate as res judicata. This question, you see the following decisions. There is no degree of importance in respect of a particular point. Very carefully read. AER 1963 Supreme Court. Very nice distinction. AER 1963 Supreme Court 385. Then AER 1971 Supreme Court 442. And the same decision, full bench of Kerala, AER 1986 Kerala 251. If a final decision on any matter at issue between the parties is based by a court on its decision on more than one point, each of which by itself would be sufficient for the ultimate decision, the decision on each of these points operates as res judicata. It should be remembered that there are no degrees of importance of an issue. Next heading, effect of fraud. Effect of fraud. Fraud vitiates everything. Even solemn proceedings like orders of court, decrees of court, everything is vitiated by fraud. If fraud persists, if fraud exists, even the decisions are vitiated by fraud. Even the decisions of the Supreme Court can be set aside on the ground of fraud. What is fraud vitiating the circumstances? It should be extrinsic to the proceedings. That very nice distinctions are made. You will get in these decisions. I will cite the decisions. 1995 3 SEC, 95 3 SEC 693. Doctrine of res judicata must however be applied to co-defendants. No, that is co-defendants. 90 AER, next is AER 1995 Supreme Court 1440. AER 2000 Supreme Court 3272. See, there is a nice distinction. When a decree is void, this is a principle which you cannot afford to forget. When a decree is void, inherently void ab initio, that invalidity can be set up wherever and whenever and wherever it is sought to be enforced, even in execution or in collateral proceedings. This is a principle right from 1950s up to date, without change, followed by the Supreme Court. Invalidity of a decree can be challenged. That a decree is null and void can be challenged at any point of time. Nullity of a decree can be challenged at any point of time. That decree is null and void. Let us take it that it is null and void. Its invalidity can be challenged at any point of time, even in execution proceedings or collateral proceedings. A separate suit is not necessary. There are certain situations where it can be raised even in execution. But there are certain circumstances where you have to file a separate suit. Those nice distinctions you will see in the decisions which I am going to cite. So fraud is also like that. See, for example, a suit is filed by A against B. On the date of filing the suit and at the time when the suit is decreed, B was a minor. Decree is void. Minor was not represented by a guardian. Or B was an insane person. No guardian was appointed. Decree is void. A filed a suit against B, which is really barred by limitation. Decree is irregular, not void. It has to be challenged. So the void and voidable nature of a decree or proceeding, nice distinctions are there. If it is inherently void ab initio, can be challenged wherever it is there. Fraud vitiates decree. Decree will be null and void. That also same principle will apply. That is why this point was also raised by me. Effect of fraud 95.3 SEC 693. 95.4 SEC 163. 2000 volume 7 SEC 543. That decision, several points are considered by Justice Jagannatha Rao. 1994 1 SEC 1. Paragraph 1. Fraud avoids all judicial acts, ecclesiastical or temporal, observed Chief Justice Edward Coke of England about 3 centuries ago. That is even now followed. It is settled proposition of law that a judgment or decree obtained by playing fraud on court is a nullity and honest in the eye of law. Such a judgment decree by the first court or the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. This is it. Finality of judgment res judicata and all those things will not apply when it is vitiated by fraud. 2000. Then another is Kerala decision you need not. Next heading, res judicata among co-defendants. This is a very difficult principle. A files a suit against B, C, D, E, F. As between A and all these defendants, some questions arise. As between the defendants, some other questions arise. I will give an example. A filed a suit for partition claiming 1/10 share in the properties. 10 defendants are there. First defendant said that none of these items are partible. Second defendant said that all these items are partible. I support the plaintiff. Third defendant said some of the items are not partible because there is a will in my favor by the father. Fourth defendant said that one item father has gifted to me. Fifth defendant said that in respect of another item, I had tenancy right even before father acquired the property. So a decision about the contentions raised by the defendants inter se is also necessary to have a finality to the litigation and to decide whether the plaintiff is entitled to relief and to what extent. Such a case, whether the decision rendered among the defendants will operate as res judicata as between them is the question. So the second suit is filed not between A on the one hand, A is not there. Second suit is filed by the first defendant against the second defendant, or the second defendant against the third defendant. So what will happen? Whether the principle of res judicata is applied to, does apply to as between co-defendants. It applies. But there are certain principles to be followed. 4 tests are there. Which are those tests? You will please note these decisions and also the tests. 1. There must be a conflict of interest between the defendants or among the defendants. That it must be necessary to decide that conflict in order to decide whether the plaintiff is entitled to relief or not. 3. It was finally decided. 4. The co-defendants were necessary and or proper parties. And the question is fraud, collusion, all those things, that always vitiates. That need not be said. So in order to apply the principle of res judicata among the co-defendants, these tests should be applied. That there was a dispute among the co-defendants. It was necessary to decide that dispute in order to decide whether the plaintiff is entitled to the relief or not. 3, the court did really decide that issue. 4, that the parties, the defendants were proper or necessary parties. If these 4 tests are satisfied, the decision rendered in the first suit will not only bind as between plaintiffs and defendants, but as between defendants as well. There is another decision of the Supreme Court that there are more plaintiffs and a decision among them is necessary, that will res judicata applies as between them also. So please see the following decisions. AER 1995 Supreme Court 1205. AER 1974 Supreme Court 749. AER 2005 Supreme Court 2499. Next heading, plea of res judicata being barred by res judicata. What is it? Plea of res judicata being barred by res judicata. A files a suit against B. B could have raised a contention. He did not raise it. No, we need not get that. A filed a suit against B. A's suit was decreed, accepting the case of A. After 5 years, in the same court, B filed a suit against A in respect to the same property, same right, same title. Then what is the defense that is available to A, the defendant? That there is already a decision in the first suit and therefore the second suit is barred by res judicata. But A did not raise that contention. He omitted to raise it. He did not raise it. And the second suit was decided in favor of B, quite contrary to the first decision. So the first suit was decided in favor of A. In the second suit filed by B, this question of res judicata could have been raised by A, but A did not raise it, and that second suit was decided in favor of B. Then immediately A realized the mistake. He filed a third suit and said that the decision in the first suit was there, that would have operated as a res judicata, and therefore the third suit must be decided in A's favor. Court said no. As between you, which is the latest one, second suit. In the second suit, you could have raised a contention that the second suit is barred by the decision in the first suit, but you did not raise it. You ought to have raised it. Therefore, explanation 4 will apply. By deeming fiction, it was decided against you. Therefore, the third suit will not lie. This is the principle that res judicata being barred by res judicata. Plea of res judicata being barred by res judicata. I will give some of the decisions, carefully read it. AAR 2000 Supreme Court 1238. It is well settled that an earlier decision which is binding between the parties loses its binding force if between the parties a second decision decides to the contrary. Then in the third litigation, the decision in the second one will prevail and not the decision in the first. Beautifully explained. Paragraph 28 of that judgment. Then some Kerala decisions are there. I have noted there. In the notes, you will not straight away get the decisions. Next heading, earlier suit for injunction. Whether a finding on title in such suit would operate as res judicata in a subsequent suit on title. First suit was only for injunction. It is well settled that in a suit for injunction, only the question of possession need be looked into, not the question of title. But there are cases where the question of title is also to be decided. Suppose there are two parties, neighbors. There is a narrow strip of property, very narrow strip of land, which is the disputed item. How to decide the dispute? Possession as such cannot be decided with respect to it. Or there is a dispute in respect of submerged land, Kyle lands, where, identifying marks are not there. So even though the suit is for injunction, sometimes it may become necessary to decide the question of title also. Then in such cases, if the title is decided, though it is a suit for mere injunction, that decision will bind the parties in respect of the subsequent suit on title, because the title was already decided in the earlier suit, though it was only for injunction. Please see the decisions. 94-2 SEC 14. Then 2005-6 SEC 56 SEC 202. 2000 volume 3 SEC 350. Then some local decisions, Kerala decisions. Next heading, cause of action different. Cause of action different. Please note the decisions. 93.3 SEC 123. And different cause of action is there. It was held that the decision will not apply. Operators res judicata in some cases. That is to be applied with cautious use. Then next heading. Ultimate decision in favor of the defendant. Ultimate decision in favor of the defendant. Findings against the defendant, whether operators res judicata. Findings against the defendant, whether operates as res judicata. This is a point. A files a suit against B. B raised several questions. I said earlier, gave the example. Suit on a negotiable instrument. B said that the suit is barred by limitation. B also said that the suit, the document on which the suit is filed is a fabricated. Court said that the document is genuine. Court also said that the suit is not barred by limitation. Therefore, the suit was decreed. The defendant filed an appeal. Defendant filed an appeal. And there, the point of limitation was considered. And it was accepted. And accordingly, the suit was dismissed. Whether the plaintiff has to file a second appeal? Yes. Plaintiff has to file a second appeal, otherwise it will operate as res judicata in a subsequent suit. On the other hand, A filed a suit against B, B raised two contentions, and the court did not accept both the contentions raised by the plaintiff. The plaintiff was defeated on both the points. Appellate court, plaintiff filed an appeal. The appellate court did not decide one point, but decided only on the point of limitation, and the suit was dismissed. But the finding against the plaintiff remains in respect of the other point. Should he file an appeal? Second appeal? No. Why? Because no appeal lies against a finding. Then the question is whether that finding will operate as res judicata in a subsequent suit. No. Why? Because what is the ultimate decision? Ultimate decision is against him. The other party need not. If the ultimate decision is in favor of a party, he need not worry about the decisions which are rendered against him, whether the findings rendered against him. If the ultimate decision is in favor of the defendant, suit is dismissed. Any finding in the judgment against the defendant on some other issues, he need not worry, because what is the ultimate result? The suit against him is dismissed. That means the defendant succeeded. Whether the successful party has to file an appeal? No. Whether the successful party who is aggrieved by some findings file an appeal? No, because no appeal lies against a finding. Appeal lies against only a decree under section 96 or section 100, whatever it is. So please see the decisions in Marangara Church case, AER 95, Supreme Court 2001, paragraph 59. Then AER 1999, Supreme Court 1823. Next heading, decree a nullity, whether res judicata applies. Answer is no. A decree which is null and void cannot operate as res judicata. Please see 1991 SEC 193. Very detailed discussion in paragraph 26 is there. Very detailed discussion. That the decree is null and void can be raised wherever and wherever it is sought to be raised and sought to be executed, or even in collateral proceedings. This is a well settled principles which we cannot forget. There are certain basic principles on the basis of which all these decisions or all these statutes work. And I would suggest, though not fully applicable, some are obsolete, still these principles are found in Broom's legal maxims. BROOM apostrophe S. Legal maxims. Broom's legal maxims. You have one book, small book. There are several maxims. You have heard ubi just, ubi remedium, or ubi just ibi remedium. When there is a remedy, right, there is a remedy also. These are all the principles. When we are sound on those principles, it will be easy for the professional to go on with the work, because we are sound on principles. You may not remember all the decisions. You can have, you will have so many search engines. You have juniors and all those youngsters. They can work on it and find out. But the principles you will not get, which you have to know, and all the youngsters should know it. Next heading, execution proceeding. Please see the decisions which are noted here. 2 Kerala decisions I have noted, including 1 decision by me. I'm not giving the citation. Please see the notes. Then proceedings under Article 226 of the Constitution. Heading. Please note the following decisions: 87-1, 1987 1 SCC 5, 1986 1 SCC 100, 86 1 SCC 100, 1990 AER 1990 Supreme Court 1607, 2019 Volume 13 SCC 42, the AER 1990 decision, very interesting. High Court dismissed a writ petition under Article 226 after hearing the matter on merits. Subsequent petition, the Supreme Court under Article 32 on the same facts, barred by the general principles of res judicata. First decision was rendered by the High Court. Appeal can be filed, no harm. But the first decision became final. Thereafter, the other party filed an application under Article 32, which is barred by the principles of res judicata. Then 2019 13 SCC 42, which I said. AER 2011 Supreme Court 2161, 2011 3 SCC 408, 1999 1 SCC 243, AER 1998 Supreme Court 2046. All detailed discussions are there in this decision. Constitution bench decisions and all those. Next heading, res judicata and order to rule 2. I said already that the Alka Gupta's case, Justice R.B. Ravindran's judgment, and there are other judgments also, carefully read it. Order to rule 2 also read. There is a nice distinction between section 11 and order to rule 2, which you will get here. 1993 3 SCC 123. Then 2010 volume 10 SCC 2010 volume 10 SCC 141. Alka Gupta versus Narendra Kumar Gupta, which I already read. 2004 3 SCC 277. Next is Land Reforms Act. I have noted some of the Kerala decisions which will apply to other states also, because if there is a land reforms legislation and exclusive jurisdiction is conferred on them, and that will operate as res judicata. And in fact, in our state, the first decision was rendered in 1978 that the principles of res judicata will apply in respect of proceedings under the Land Reforms Act. And thereafter, the Land Reforms Act was amended in 1979, stating specifically that Section 11 will apply. So there is no difficulty for that point now. And also check up the particular subject matter in the particular states. In most of the tenancy in any matter and barring under Section 9 of the CP. Northernmost tip bordering very rich of the soil and the kind of breed they are getting high.
Excuse me, sir.
Hello. Sir, am I audible to you? We are not able to hear your voice.
Excuse me, sir. Your voice is, you are on mute actually.
I am unmuted. Can you hear me?
Yes, sir, you're audible now.
Can you hear me now?
Yes, sir, you're audible now.
There was some problem, connectivity problem. Your internet connection is unstable is what is written here. Yes. Now there is in that area, there is a strange division. Sometimes the property unequal division will be made. And the person who got more property will be bound to deliver particular quantity of recurrent every year to the other party who got lesser extent. Every year without fail. And every year there will be litigation. The party will not deliver. What is the price to be taken into account, whether it is the Kerala rate or Karnataka rate, is a question every year. And ultimately, the court will decide the value of the recurrent, and that will be over that year. Next year, also, same question arises. Then somebody raised the question. Last year, this was decided at this manner, in this manner. Therefore, that will operate as res judicata. Court said no, because value of a recurrent fluctuates every year. Therefore, there is no finality to the decision, and therefore it will not operate as res judicata. Then last heading, res judicata and estoppel. Justice Mahmood of Allahabad High Court in Sitaram versus Amir Begum, 1886, 8 Allahabad, 1886, 8 Allahabad, 324 said the distinction between res judicata and estoppel. I'll read. Perhaps the shortest way to describe the difference between the plea of res judicata and an estoppel is to say that while the former prohibits the court from entering into an inquiry at all as to a matter already adjudicated upon, the latter prohibits a party, after the inquiry has already been entered upon, from proving anything which would contradict his own previous declaration or acts to the prejudice of the another party, who relying upon those declarations or acts has altered his position. In other words, res judicata prohibits an inquiry in limine, while estoppel is only a piece of evidence. With that, we will close this session on res judicata. And only 5 minutes to 1. It is for you to decide whether we have to touch other aspects also. Or if you are ready, I will within 20 minutes, I will give a fair idea as to how those subjects are to be learned.
Sure, sir. We can do in 10-15 minutes as an overview, so audience get an idea about that as well.
So I am asked to say revision, appeal, second appeal, revision, review, reference. These are the subject I was requested to deal with. Appeal. You may see section 96, which says that every decree of a civil court is appealable. To which court appeal lies, that depends on the Civil Courts Act of that particular state. The valuation, jurisdictional value, and all those things. Sometimes if higher value is there, the appeal lies directly to the High Court. In some other case to the District Court. If it lies to a court other than the High Court, from that decision a second appeal lies under section 100. So we have to see an appeal. Which are the provisions to be seen? Section 96, section 100, second appeal. And along with section 96 and 100, you have to see order 41 also. Order 41 also. Appeals from orders. This I said appeals from decrees first. Appeal from orders. You have to see section 104. And also order 43. Section 104 and also order 43. Now, what is the difference between decree and order? Decree is defined in section 2.2. Means a formal expression of an adjudication which so far as the parties concerned the court decides it finally. It may be preliminary or final decree, etc., etc. 2D, 2.2. Decree means the formal expression of an adjudication which so far as the court expressing it conclusively determines the rights of parties, and it may be either preliminary or final. Shall be deemed to include the rejection of a plaint. Rejection of a plaint, you please note order 7 rule 11, and determination of any question under 144, that is restitution, but shall not include any adjudication from which an appeal lies as an appeal from an order. Please note section 104 and order 43. Any order for dismissal for default. Please note as against it order 9 rule 8 and order 9 rule 9. You have noted? Decree definition is there in section 2.2. It says that it may be either preliminary or final. That happens. And if there is a final decree for partition, preliminary decree for partition, you will have to see order 26 as well. If it is a mortgage suit, you have to see order 34 also. So everything is connected, interconnected. You have to find out by yourself where it is there and find out whether there is any connecting link. Between the section and orders. Now, clause A, any adjudication from which an appeal lies as an appeal from an order. I said that section 104 and order 43. Any order for dismissal for default, that is order 9, rule 8 and rule 9. Then decree holder. Order means section 214. Order means the formal expression of any decision which is not a decree. Please see rule 218. Rules means rules form and forms contained in the first schedule or made under section 122 or section 125. That is rule committee. So this is it. Appeal. Please read these provisions. 96, 100 and order 41. Along with section 22 and the provisions which I mentioned. And then order means 214. Appeal against orders means are dealt with in section 104 and order 43. So that appeal part is over. You have to carefully read it. Read the commentaries also and understand it. And master it. First, the connection between the two must be realized. The next subject is revision. Revision is contained in section 100. There is no section 50, 150. 115 underwent a great change by the 99 amendment, 99 CPC amendment. And by the by, I may say that those who are beginners, who have not seen the amendment in 99 and 2002, after 1976 major amendment of CPC, the next major amendments came in 99 and 2002. Both these amendments bills were considered on the same day and both were passed on the same day. Two amendment acts of 99 and 2002 came into existence and became operational from 1/7/2002. And the constitutionality was challenged before the Supreme Court by Tamil Nadu Salem Bar Association. There the Supreme Court appointed a committee to look into it. That committee consists of Kapil Sibal, Arun Jaitley, and a host of others, Bar Council Chairman, and several other prominent members of the bar. They submitted the report. After submitting the report, the court again considered it and passed a judgment, detailed. These two judgments are reported in AER and SEC. One is 2003, the other is 2005. 2003 and 2005. Salem Advocate Bar Association. Salem Advocate Bar Association versus Union of India. And both these decisions should be read in full. Make note of it so that you will understand what all changes were made and what is the scope and ambit of the amendment after 76 and before 76 and after 76 and before 99 and after 99 and after 2000. can be categorically studied and you can master the subject, provided you read Salem 1 and Salem 2. Salem Advocate Bar Association 2003 and 2005. And incidentally, the Section 89 was amended to a great extent, and the scope of Section 89 was considered by Justice R.V. Ravindranath of the Supreme Court in Afcon International versus Cherian Workey Constructions. Afcon Infrastructure Limited versus Cherian Workey Constructions. Please read that judgment in full. These three judgments you must read, might and not. You must read, so that you will get a fair idea of the amendments, etc. Now we will come back to section 115, revision. What is revision? Revisional power belongs to only the High Court, not to any other court. Let us see what is 115. 115, 115 says, the court may call for the record of any case which has been decided. The High Court may call for the record of any case which has been decided by a court subordinate to the High Court, in which no appeal lies thereto. And if the subordinate court appears to have three conditions, must be satisfied. Any of the three conditions. What are the conditions? To have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of jurisdiction illegally or with material irregularity. These 3 points centers around on jurisdiction. So a revision lies on jurisdictional issue. One is that the court exercised a jurisdiction which does not have, or court has a jurisdiction but it failed to exercise, or 3, exceeded its jurisdiction. In either case, the High Court could interfere in revision. But there is a proviso, provided that the High Court shall not under this section vary or reverse any order made, or an order deciding an issue in the course of a suit or a proceeding, except where the order, if it had been in favor of the party applying for revision, would have finally disposed of the suit. So this condition must be satisfied. That is, the party applying for revision, the order had been in his favor, it would have finally disposed of the suit or proceeding, in which case only the court will interfere. So such cases are very rare, rarest of rare. But before the amendment in 99, what was the position? This proviso contained 2 parts. One, A and B. B was the court for order, if allowed to stand, would occasion a failure of justice or cause irreparable injury. So revision can be exercised by the High Court on the jurisdictional aspect, on satisfying either of the 3 conditions regarding jurisdiction, that is, exercised a jurisdiction not vested in it by law, or exceeded its jurisdiction, or failed to act on a jurisdiction. If any of these conditions are satisfied, the revisional court can interfere, but it is circumscribed by a proviso that provided that the court will not alter or set aside the order of the trial court, subordinate court, unless if the order had been the other way about, it would have disposed of the suit or proceeding in favor of the party applying for revision. This condition must be satisfied. It had another wing before 99, that if the order is allowed to stand, it would occasion a failure of justice or cause irreparable injury to the petitioner. That was the clause under which earlier, before 99, almost all the revisions were being filed. And in appropriate cases, the High Court could have interfered on that ground. The order, if allowed to stand, would occasion a failure of justice or cause irreparable injury to the petitioner. It is based on that ground. That ground was taken away from the proviso. Clause B was taken away, and there is only one single clause now. That created the difficulty for the litigants, and therefore they found out a method to overcome it they started filing writ petitions. Then the Supreme Court said writ petition will not lie, you can have original petition under Article 227. Then Article 227 petitions came. And the number of revisions when the revisions were maintainable, and the number of original petitions filed subsequently after the amendment, when you count the number of original petitions, the original petitions were more. So the purpose on which it was sought to be curtailed by the deletion of a proviso, part of the proviso, was defeated by the lawyers preferring to file original petitions under Article 227. Even for denying adjournment, court parties started filing 227 petitions, which were not being entertained earlier under Revision 115. So the purpose which was sought to be achieved by the amendment by deletion of a portion of the proviso did not achieve the result. Please make a thorough study of it. Then reference is that if there is a question of 114, read with Order 46. Review Order 47. I'm sorry, reference is 113. Read with Order 46. Review is 114. Section 114, read with Order 47 of the CPC. Please read it. So that subject I have introduced did not take because of paucity of time. It is not possible. There are only 2-day workshop. Therefore, it is not possible to have on another day. We will complete it by this. And I am very sorry I could not explain in detail the second set of subjects because it is paucity of time. Appeal itself will take 2 or 3 hours minimum. So thank you very much. Bye.
Thank you very much, sir, for this enlightening speech. This session is now open for a question hour round. Any question on board can noted in the chat box. Sir, with your kind permission, I would like to ask the audience first question.
Yes.
Yes, sir. Sir, what a legal course is available when the value of property exceeds the jurisdictional limit of the local court specified in section 16, but falls below the pecuniary jurisdiction of High Court as outlined in section 6, considering the provision in section 120 that restricts the courts from taking up the matter.
The question I did not fully understand because it is also intertwined with the local legislations, but I will say the principle. In every state, there will be a Civil Codes Act. Civil Codes Act will define the pecuniary limits of jurisdiction of the junior division officer, senior division officer, district court, and high court. High court is not there. Senior division officer usually sub-judge in our state, subordinate judge, unlimited jurisdiction. So it depends on that the Civil Codes Act, the pecuniary jurisdiction is decided. And the appeal, second appeal, and also decided. Second appeal lies only to the High Court under Section 100. If the valuation of a suit is very high, that is depends on again the state law, whether it is 10 lakhs some states, 20 lakhs in some other states, or 40 lakhs in some other states. If it is above that, the appeal directly lies to the High Court. If the appeal directly lies to the High Court, suit, appeal, then further appeal to the Supreme Court. Whereas if it is a smaller court, namely the junior division officer, then the appeal lies to the district court, and then second appeal lies to the High Court. That depends on the state law of Civil Codes Act. Court fee also depends on it. This is what I say in answer to that, because that answer relates to the local law on the subject. Yes.
Sir, second question. What are the key elements required to prove a case in civil court? And how does burden of proof differ from criminal cases?
Yes. How a case is to be proved? The burden of proof on whom? Burden of proof is you will get in section 101 to 101 to 106 of the Evidence Act is my memory. I will check up 1 minute. Yes. Chapter 8 of the 7 of the Evidence Act of the burden of proof. It starts at section 101, ends at section 106. No. Ends at section, and that chapter goes further, but mainly section 106, 1 to 6. Then the burden of proof is there in other sections also. Presumptions are there, etc. So the burden of proof lies on the person who would fail if no evidence is adduced. Then fact, especially within the knowledge of a person, that person has to prove. Positive things are to be proved. In criminal cases, the position is different. There, it is proof beyond reasonable doubt. Whereas, under the civil cases, it is preponderance of probabilities. There is in criminal cases also, there is an area where preponderance of probabilities will prevail. That is where a self-defense is pleaded by the accused. There also, he need not prove to the hilt, as in the case of prosecution. He need not prove. But see the POXO case, where the burden under section 28 and 29 of the POXO entirely rests on the accused. And there it is made clear that it is not preponderance of probability, but the burden proof beyond reasonable doubt that is required even on the side of the accused. So normally in civil cases, it is preponderance of probability, but generally in a criminal cases, except where special statute which provide otherwise, it is proof beyond reasonable doubt. Yes.
Third question, sir. What are the options available for alternate dispute resolution in civil cases, such as mediation or arbitration?
All these 4 conditions are there in section 89. 89 starts with when the court finds that there are elements of settlement in a case, the court shall formulate this same and hear the parties, reformulate it, and refer to arbitration, conciliation, judicial settlement, or something else, that is legal authority. And it is
Okay.
various clauses A to D also says that when it is referred for arbitration, what will happen? When it is referred for mediation, what will happen? There, in that case, a question arose before the Kerala High Court that whether an unwilling party can be referred to arbitration. Because arbitration, the basic principle is that there must be an arbitration agreement between the parties. Then only it can be referred for arbitration. But in that case, the Kerala High Court made an innovative approach and said that even if the party does not opt to do, even if there is no agreement between the parties to refer the question to arbitration, Section 89 should be purposely interpreted. And in such case also, the court, even if the parties do not agree, the court can refer the case to arbitration. That was challenged in Supreme Court. And Supreme Court in Afcon Infrastructure versus Cherian Workey Construction, which I mentioned earlier, set aside the judgment of the High Court and said that unwilling parties cannot be referred to arbitration. And what are the principles and all those things. And incidentally, the court looked into the various amendments which were made in Section 89 and said that there are certain fundamental flaws and reformulated it. The court said that the clauses are to be changed. Clauses C and D are to be interchanged. And the court also said that in the opening portion, when the court shall formulate the possible terms of settlement, that happens in the final stage of mediation, not earlier. And therefore, the court said that how this is to be approached, which cases can be referred under 89 to arbitration, conciliation, all those things. ADR methods are available in which case it cannot be done. All those categorization was made in Afcon Infrastructure. Yes.
Thank you, sir, for the answer. Looking at the time contingency, now we end the question our round here. I would like to invite Ms. Hiranshi Shah, founder of Sambhav Initiative, to deliver a vote of thanks for the today event. Over to you, ma'am.
Uh, Thank you, Rahul. First of all, thank you so much, sir, for this wonderful session. Now begin. So to all dignitaries, team members, and the ladies and gentlemen, it gives me pleasure to extend first my sincere gratitude to our own patron and chief and the patron, Justice C.K. Thakkar sir and Justice Emma Shah sir, former judges of Supreme Court of India, for their invaluable advice and support to the Sambhav initiative and also for this organizing this wonderful workshop. On behalf of the Sambhav initiative, now I would like to express my sincere gratitude to Justice K.T. Shankaran sir, member of Law Commission of India, for accepting our invitation and sharing this their valuable knowledge will definitely enlighten the audience, not only from the theoretical perspective, but also, sir, enlargen them with the practical aspect. Thank you so much, sir. It was a very wonderful sessions, and we have learned a lot today from you. I would also like to thanks to all attendees for giving up their valuable time and join us for this wonderful workshops. And lastly, I would also thanks to Sambhav Initiative team members, Jayan, Jatayu, Mahek, Rahul, Muskan, Sanvi, and our technical assistant person, Ishan, for their work. And due to them, this event is possible to be organized. Thank you so much, everyone. Have a great day ahead. Thank you so much, sir.
Thank you. You send your email ID to which the notes are to be sent.
Yes, sir.
If I
Sure.
get it now itself, I will send it.
Yes, I will send them.
Or if it is sent later, I will send it on Monday.
All right, sir. I will send
Ah.
it today itself.
Later, I have to go home now. I am in the office now.
Yes, sir.
This is
So
Saturday, not working. Is this specifically open for this purpose?
yes,
Otherwise,
sir.
I could have done at home, but because of the poor connectivity, I have to move.
Yes, sir. So it's a very great honor for us that on the Saturday you just open up the Law Commission of India for specially for this event and workshop. Thank you, sir.
Thank you very much. Wish you all the best.
Thank you so
And
much.
also the participants wish you all the best in the profession. And I would say that lawyer's profession is a wonderful profession. There is nothing like any other profession. It is quite different. Yes, thank you. We'll see. Can I leave the meeting?
Sir. Thank you, sir.
Thank you.